Okay, great. Welcome, everyone, to the Palm Beach County Bar Association's Town Hall discussion on the Florida Rules of Civil Procedure Amendments. I have with me here at Greenberg Traurig, Dawn Whitfield, my legal assistant, who is going to be making sure that you all see the PowerPoints. I think that you should all be able to see Judge Sarah Schulman, and also Judge Joseph Curley. Actually, is Judge Curley?
Yes.
Okay, wonderful. Thank you. And again, this is presented by the Palm Beach County Bar Association. We'd like to thank Kathy Clark from the Palm Beach County Bar Association, as well as Jessica Gonzalez, who have helped us to put this together. And without further ado, I'd like to pass this on to Judge Curley, who is now the Chief Administrative Judge of Circuit Civil, and Judge Schulman, who is the Chief Administrative Judge of County. Thank you.
All right. Thank you, Bridget. Next slide. Okay. The goal of today, just let me give you a little overview. What we're hoping to do today is to heighten everybody's awareness of the coming changes to the rules. As many of you may know, the changes to the rules have been in process now for a couple of years. The idea behind the changes was to streamline the process, to try and make it more efficient. The goals I'm going to talk about in just a minute. I mentioned those things so that as we go through the changes, and we're going to go through the highlights of the changes. What we do today in the hour that we have is by no means intended to replace a pretty careful study of the changes themselves. The good news is you've got time to do that. The materials that you're going to see in our presentation will be accessible to everyone shortly after the presentation's finished. At the end of our PowerPoint, you'll see a red line version of the rule changes. So you'll be able to see exactly what the changes are, how they read, and hopefully, because of our presentation today, Judge Schulman and I will be able to help you address those things that may require attention as we go forward. The rule changes themselves came about, and I want to read to you the administrative rule that was entered on September 1st, 2023, a couple highlights. The administrative rule was put in place to impose strict trial schedules to ensure timely resolution of cases in accordance with the standards specified in Rule 2.250 of the Florida Rules of General Practice and Judicial Administration. The rule places responsibility upon judges and attorneys to actively manage their cases. The changes put in place firm deadlines for pretrial matters and trial readiness. The intention of the rule changes is innovative ways to improve fair, predictable, efficient, and timely disposition of cases. The administrative order is intended to provide greater uniformity and predictability to the management of civil cases pending in this circuit. So that's a quote from Judge Kennedy, a Supreme Court Justice. People are going to have to understand that when they come to court, they need to be ready to go. If they're not ready to do that, then they probably shouldn't be filing a complaint. When he made this quote originally, what I call the bookend of the rules was not in place. It's in place now. And we're going to work our way through that. The changes that you're going to see, again, streamline the process. There's bookends to the changes that are in place now. They weren't in place before. As an example, this started out with the DCM orders intended to give people deadlines for the case and preparation of the case and resolution of the case. At that point in time, judges were wondering, how can we force people to get there? Well, you'll see in a moment, they've eliminated the ad issue rule and some other things that now give the ability to get certain things done. They've added an ability to do other things. Next slide. The highlights of which are as follows. Rule 1.20, cases are now going to be designated on a case management track. That'll happen at the outset. 1.202, that creates a duty to confer before filing any non-dispositive motion and a detailed certification requirement. Rule 1.280. This adds the federal proportionality rule to our discovery. It also adds a duty to provide initial disclosures and a duty to supplement discovery. As I mentioned, Rule 1.440, the ad issue rule is gone. Cases get set for trial. They're going to be set at the outset. We'll talk about that. And they won't move absent a continuance. Rule 1.460, continuances are disfavored and should rarely be granted, and then only upon good cause shown. Finally, Rule 1.510. The deadline to file a motion for summary judgment is set by a case management order, and the response is due no later than 60 days from service of the motion. Point of that change, it's no longer tied to when the hearing date is. Next slide. So it's a complete rewrite of 1.200, the case management rule. The subsections, as you can see, are as follows. You've got applicability, what it applies to, what the DCM orders apply to, and what they don't. Case track assignments, when they're made, how they're made, how to change your track assignment, the case management order itself, the extensions and modifications, the case management conferences, and finally your pretrial conference. Again, all of these things are in the rules that will follow the red line version. So you'll have that when we're done available to you. Next slide. So this is the first part of the rule that deals with case assignments. In streamlined and general cases, the rule states that the court must issue a case management order that specifies the projected or actual trial period based on the case track assignment. Here in Palm Beach County, 15th Judicial Circuit, that case management order is going to be issued at the outset of the case. It'll be served when the complaint is served, and it'll assign an actual trial period, not projected, actual. The deadlines must be differentiated based on whether the case is streamlined or general and consistent with the time standards that are specified in the Florida Rules of General Practice. That's what I read from to begin with. That's what the rules will require. We already have case management orders in place in the 15th Judicial Circuit. We have standardized DCM orders, as most of you know. And as I said, the cases are assigned automatically to a streamlined or a general track based on whether a jury trial is demanded or not. Next slide. So a non-jury or a county jury case, that's assigned to streamline. You got 12 months. Jury trial, a general jury trial, you get 18 months, and then complex cases up to 30 months. We'll talk about how cases are assigned to a complex case designation. One thing you're going to see pretty quickly is that is no longer in the hands of the attorneys. They can ask a judge to do it, but the judge has to make that decision on his or her own.
Judge Curley, before we move on to the next slide, you made a point of distinguishing between an actual and a projected trial date. Do you want to talk about that a little bit more now?
We can. We're going to talk a little bit more about it later, but the bottom line there is when you get your case management order, it's going to have it's going to calendar the case, and that will be your trial period. So you're going to have an actual trial period as opposed to previously, because of issues with the ad issue rule, there was just a projection. Now it's going to be an actual trial date, and we'll talk about the manner in which the rules now allow you, if you need to ask to change that, what the process is for that. The rules are very specific, or will be very specific. Again, these rules kick in January 1, 2025. So we have time. This whole presentation is so that everybody, judges and attorneys, can be ready when it becomes actual. Okay, next slide. So I mentioned before the DCM orders. This is just the heading on one. This is the general track. You all are getting these or will be getting these. And the thing to note is the way the rule reads now is it's disposed of within 18 months from the date of filing. So the trial dates that you're going to get will be approximately 15 months out. It gives a little bit of room, but it's 18 months from the date of filing, not service. Next slide. Okay, the rewrite of the rule covers a number of things that will go into the initial case management order. It'll address service of the complaint. It'll address service of extensions, how to add new parties, completion of fact discovery, completion of expert discovery, resolution of all pretrial motions, and completion of alternative dispute resolution. We'll talk a little bit in a few minutes when we get to summary judgments about what we perceive as the need to include language regarding summary judgment motions and things of that nature. Next slide. Here are some of the dates that we're going to be dealing with. So as you can see here, these are the target dates that are going to be in the case management order. Some of the things that we will probably address have to do with summary judgments, the actual pretrial itself. The rule will provide for a mediation date. We'll be adding that. Another thing that the rule now provides in multiple places is that these deadlines are to be strictly enforced. That's the quote. When we get into the new rules, the idea will be that these deadlines become hard and fast. The rules provide for mechanisms of enforcement. What does that mean for things like Banger and other such issues? Probably not going to be as useful or popular as they once were. Okay, next slide, Judge Schulman.
All right, good afternoon, everyone. So here we're talking about some of these subdivisions in Rule 1.200, and I would strongly encourage you to read the rule. You may need to read it a few times because it's heavily nuanced, as stated previously, between actual trial periods and projected. We're going to help you with that today, but the subsections really walk you through the progression of a case. So right now we're still in case management world. And the first point is that a track change request must be promptly filed after the appearance of good cause. What is a track change request? Well, for example, if the complaint did not demand a jury and you got assigned to the streamlined track in circuit, which is 12-month time to disposition, defendant demands a jury, you need to change now your designation to a general track to allow for 18 months time to disposition for a jury trial. Most of us will allow you to simply upload a proposed amended DCM when it's something that simple. if it's more complicated than just a jury demand, go ahead and file a motion and get it heard as quickly as possible. So deadlines must be strictly enforced. There are provisions in place in subsection E for modifying the deadlines. Now, the parties can extend the deadlines if the extension does not disrupt the remaining schedule, and this is where it gets tricky. If one particular deadline will impact remaining deadlines, then you have to address it through a different manner, and we're going to get into that. So just keep in mind, you really need to figure out what it is you're trying to do and whether you're affecting multiple deadlines, or if you're affecting the trial date, that's a completely different story. I'm going to get into in just a second. Next slide. So this is subsection E1 in particular. If the parties agree, they may submit an agreed order to extend a deadline if the extension does not affect the ability or the remaining dates. Now, if the change does affect a subsequent deadline, the parties must seek an amendment of the case management order. So I know this is, very nuanced, but it's going to matter, and the rules committee, it mattered to them. So just keep that in mind. One deadline, just file an extension. If it's going to affect multiple, seek an amendment of the DCM, because now we're going to have to change all the remaining deadlines. We're not yet talking about motions to continue trial, just deadlines that still meet the same trial period. Next slide. Okay, here we go. A request to modify an actual trial period is governed by a different rule. And this is the key here. As Judge Curley mentioned and Bridget asked, what's the difference between projected and actual? So if you receive a case management order, and you may in other circuits with a projected trial period, you can use this case management rule to get a continuance of the trial period. In the 15th Circuit, we set actual trial periods in our DCM. And because of that, if you need to continue the actual trial period, you have to file a motion to continue under Rule 1.460. The good news about that is that a new trial order does not have to be issued in every case, where it would be in a case that only has a projected trial period. That means in all those cases, the judges have to enter second trial order setting the case 45 days out. Ours are designed to be entered day one. You know what your trial date is, you know what your deadlines are, and hopefully, unless there's a real reason to move it, we don't have to keep issuing orders, and you don't have to keep asking for changes. So that's the difference between actual and projected. If you need to continue, you file a motion under 1.460. Next slide. Okay, if you look at the bottom, it cites E3. So again, go through the rule itself. It tells you exactly what you need to do, but this is for modification of deadlines of a projected trial period. We're providing it to you in here, but it's also that doesn't apply in the 15th, but it's also to extend a deadline. Here's what your motion needs to say. I'm not going to go through it in detail now, but please be cognizant of this rule. You can't just say we agree and we need an extension. Next slide. All right, so I know every person on here is wondering, what do we do about hearing time? This is all fine and dandy, and we'd love to go to trial in 18 months or 12 months, but we can't get our motion to dismiss heard. We know this as judges, the attorneys know it. The Rules Committee apparently knows it, because I'm going to read this one. If any party is unable to meet the deadlines set forth in the case management order for any reason, including the unavailability of hearing time, the parties may set a case management conference and alert the court. That is your tool when you are having trouble moving the case along because you can't get important motions heard, let us know. Set a case management conference. You may, if you can't get hearing time on a special set it on UMC. Just do whatever you have to alert the judge that we are trying to meet these deadlines, but we can't, and we need you to give us some hearing time or work with us here. And if you do that, you will not be in trouble, so to speak, with the division judge. So that is your tool right there. Subsection H is self-explanatory. I will say though, keep in mind, we're going to talk more about the at issue rule. Not setting a motion to dismiss for hearing is not going to be a reason to move the trial in the future. We're going to trial whether it's at issue or not. Next slide. All right, so now we're talking about the case management conference. So the case management conference is the term of art used by the Rules Committee, but think of it as the calendar call for our DCM purposes. Our trial order sets a combined case management conference and a pretrial conference where you talk about jury instructions and whatnot. But you can also have multiple case management conferences throughout the litigation, so don't be afraid to set them. A couple interesting notes that the parties can set a case management conference. You have to follow Rule J there. The court can set multiple. The court can address all scheduling issues during this time. And also, with notice and time, the court may elect to hear any pending motion during the case management conference. So other than a motion for summary judgment and evidentiary hearings, but just be ready. If we're going to a case management conference and we're trying to move things along, chances are the judge is going to say, let me hear that discovery issue right now. You'll be given notice, but just be prepared. Next slide. All right, so real quick, J5, at the end of the case management conference, the court either issues a deadline to provide a proposed order or does it self. And then J6, I want to emphasize, particularly for county, there is now written in a rule that upon failure of a party to appear, the court may dismiss the action or strike the pleadings. So that tool was not available before. I know that many people who are probably on this presentation have had the frustration the other side doesn't appear and the judges don't have really any tools to deal with that, and now we do. Next slide. So the rule also contemplates the pretrial conference, which again is akin to your calendar call. Our DCM set everything, calendar call, pretrial conference, case management conference, all on that calendar call date. And this is your typical, let's go through jury instructions, how many days for trial, use of technology that's going to be needed, order of proof at trial, etc. So that looks more like your normal jury trial order. And next slide, Judge Curley.
Okay, thank you, Judge Schulman. Now we're up to amendment to Rule 1.201 for complex cases. As I mentioned earlier, it's now going to be up to the judge to designate. I think probably they made that change so that people wouldn't seek the 30. You get 30 months for a complex case, 18 for one that's not. So maybe there might be a desire to get to 30 months if you think it's going to take a while to get there. This can be teed up in one of two ways. The judge can either look at it and decide this is a complex case, or you can file a motion asking the court to designate it as a complex case. The clerk's not going to do it in any instance. So when the case is filed, it's not going to be designated as a complex case unless for some reason it goes in front of the judge. I cannot imagine that happening. So you may have a case that you think should be complex, and you may wonder why it wasn't automatically designated as such. Maybe it's a class action or something like that that would typically fall into that category. It's not going to happen automatically. You just file a motion and ask the judge to designate that. In those cases, Next slide. Those cases, as I said, the court must enter the case management order. What'll happen there, and I'm sure it happens with most judges, if it's designated as a complex case, I've got various orders that I enter. It sets there's a lot of management that goes into complex cases. There's a lot of reporting that goes into it. And the case management orders that you'll get will provide for multiple case management hearings and things of that nature, which, because you got 30 months, you have enough time to do that in an orderly fashion. The rest of the rules pretty much apply. Next slide. So what's a complex case? Again, I'm going to skip down. I'm not going to go through the entire thing, but I do want to talk about two things that are provided here. At the end of the first paragraph, it says the court shall convene a hearing to determine whether the action requires the use of complex litigation procedures. Once it's brought to the court's attention, that onus falls on the court, and we'll do that. The second part of it is, what's a complex action? Complex action can be a variety of things. It's not necessarily complex because there's a lot of money at stake, or there isn't a lot of money at stake. It involves complicated legal or case management issues and requires extensive judicial management to expedite. So when you're asking for a designation, be prepared to explain to the judge why the case requires those things, and then the judge will make that decision. Okay. Next slide. Judge, back to you, Judge Schulman.
All right, next slide. Rule 1.202, for those who practice in the 15th Circuit, this should not be completely new, but it is a new rule. You are now required to confer before filing your motion. Our local Rule 4, which has been in existence for as long as I can remember, already requires the parties to confer when setting a hearing such as UMC or special set. And you absolutely have to confer before the hearing occurs. So you're going to have to read our local Rule 4 in conjunction with this new rule now before you even file the motion, except for dispositive motions or for injunctive relief. You have to confer with the opposing party ahead of time. And in your motion, you must file a certificate of conferral. So we're making everything happen earlier. Try to resolve things as early as possible. And this rule, I'm not going to read it in word for word, tells you exactly what you need to do if you are having issues receiving a response from the other side. As we've always said with local Rule 4, you can't just say, I tried once and didn't hear back, so here we go with the hearing. The Rules Committee and the judges really appreciate as well, but require a good faith conferral and want to see that happen. Next slide. I've already mentioned this, just make sure that you do file that statement and that you follow the rule. Next slide. Okay, so in particular, we wanted to highlight that you have to describe all the efforts undertaken to accomplish dialogue prior to filing the motion. And you also are giving us as the trial judges the opportunity to address problems at the hearing. So we're already going to know from having read your certificate what's going on, and we can talk to you. We can help resolve these things. Maybe we can set deadlines in place that when you email, they have to respond within the next days, etc. Next slide, Judge Curley.
Okay, thank you. Just one thing on suggestion on the last slide. Can you go back to that for just 1 second? Backwards. Okay, I'm testing you. If you're the other party and you see this certification on a motion that's filed, don't just wait for the hearing. Pick up the phone and call and say, look, I'm available. I want to talk about this. Don't wait till you get to the hearing. to address it. That would be my suggestion, okay? Next slide. These are some of the bigger changes in terms of discovery that have been made. There are a number, but these are, for those of you who practice in federal court, just to make it simple, most of the changes here all came directly from federal court. Most of my practice before becoming a judge was in federal court. This may seem a little daunting to some of you, but that haven't operated under these rules, but I'm telling you, it will make life simpler. The reason I say that is it's self-effectuating for most of it. The deadlines are in place. It's designed to streamline the process and allow the parties to get to what is really important in the case. So let's talk about the key changes here in 1.280. First, it incorporates proportionality language from the Federal Rule of Civil Procedure. We're going to talk about that in just a second. We'll spend some time on that, and our materials that you get have some cases from federal court that address the proportionality analysis in real simple manner. I'm pretty sure for a while we're going to be borrowing the federal court case law to address that to the extent that we need it. Second, 1.280 is amended to require initial discovery disclosures. So within 60 days after service of the complaint or joinder, unless a different time set by the court, there'll be initial disclosures that are required, not just by the plaintiff, but by both sides. It's interesting. That doesn't mean you can't engage in discovery before that, because it's 60 days out. The rules allow for some discovery before that. I'm not sure exactly how that's going to be impacted as things go forward, but it's 60 days out. And then thirdly, the rules are amended to impose a duty to supplement discovery. We're going to talk about that too specifically. Next slide. This is the disclosure obligation. Next slide. This is amended to require certain initial discovery disclosures within 60 days, as I said. Next slide. What are they? They're four. They're very specific, and we'll go through each real quickly here. But let me say this: the quote that we had for you at the beginning from Judge Kennedy. This is where it really starts to hit home. When you file the complaint, you should probably have all these things at the ready. You've got 60 days to get there. And there may be times when you don't have everything and you can't wait, but those should be the exception in large part. Just a note to be mindful of. Next slide. This is a copy of the key documents, electronic storage, possession and custody, that you may use to support the claims or defenses. All right. Unless the use would be solely for impeachment. We're going to debate that later, is my guess, the impeachment one. So there's some wiggle room in there for those who like it. Next one. Damages, computation of each category of damages claimed by the disclosing party in the documents that support it, etc. This production may facilitate easier settlement discussions. We'll see, but the obligation remains. Next slide. And then finally, any insurance policies or agreements regarding insurance. Next slide. These are the unacceptable practices. So the Rules Committee was aware that sometimes objections are raised or excuses are made. And this one, this is pretty clear. A party is not excused from making its initial discovery disclosures because it has not fully investigated the case, or because it challenges the sufficiency of the other party's initial disclosures, or because another party has made its initial discovery disclosures. A party who formally objects to providing certain information is not excused from making all other initial discovery disclosures. So objections notwithstanding, the discovery disclosures need to be made. Next slide. Proportionality. Proportionality, next slide. So here's the rule. It says that it incorporates a proportionality analysis from Federal Rule of Civil Procedure. So we know we can borrow from federal case law for this. And then it goes on to say parties may obtain discovery regarding any non-privileged matter that is relevant. So let's stop there for a second. So the first part of the analysis for proportionality is going to be, is it relevant? In your mind, think that's the rest of it is going to be a subset of relevance. So you've got relevance. There's a question of how relevant it is, and then let's go on to any party's claim or defense and proportional to the needs of the case, considering, and then we've got a bunch of factors that we can consider here. So your analysis on the front end, is it relevant? Okay, so it's relevant to some extent. Then the next question is going to be, the way I say it is it worth it? There's a lot of factors you can consider, but is it worth the time and expense to go get this relevant information? Who bears the burden? That hasn't been fished out yet, but the good news for you all is in the cases that are attached to the materials, it talks a little bit about that. The burden really isn't on either party. The burden on the proponent is going to be to show why it's relevant and really to what extent it's relevant. Is it really important stuff, or is it on the fringe and it'd be nice to have, but it's really not going to change the outcome, at least in most people's minds. And then on the other hand, how hard is it to get that? What's it going to cost? What's the expense? Et cetera, et cetera. So the simple analysis for proportionality, is it relevant? How relevant is it? And is it worth it to go get it? So if you want the information, be ready to show the judge why it's important, why it's relevant. If you're arguing that it's too expensive, it's an undue burden, it's not worth it, it's a fishing expedition, whatever, however you want to characterize it, be prepared to explain to the judge why those things are true. That's the dialogue to have. Next slide.
If I can add something for county,
I'm sorry.
if I can add something for county.
Oh, for sure.
As a wise colleague of mine pointed out, in county, our jurisdiction is up to 50,000, but we have plenty of cases that are, they might be business cases in nature, but they're filed as small claims. Perhaps attorney's fees are at issue, but they might be anywhere from $100 to $49,999. So that proportionality impact in county cases is really going to come into play. If you're looking to have, experts and CSI and ESI spending hundreds of thousands of dollars, the scale is going to go perhaps in the other direction. It's something to think about for down the line.
That's an excellent point. So finally, supplementing discovery. We now have a duty, and I think the last time I checked, 49 other states all had this duty in place. I think we might be the last state to impose this duty, if I'm not mistaken. So now we have a duty to supplement discovery. There's still be some discussion about it, but skipping down to subparagraph 1, in a timely manner if the party learns that in some material respect, the disclosure or response is incomplete or incorrect. And if the additional or corrective information has not otherwise been made known to the other parties during the discovery process or is ordered by the court. So what's not here is a deadline to supplement discovery. What I'd suggest to you is that it's probably due before the discovery cutoff. And the question will be asked, why did it take so long? Things of that nature. And is it produced in a timely manner? That's what the rule says. Timely probably means you produced it not long after you found it or found that it exists at a time when the other party, it wasn't too late for the other party to address it or use it. And then lastly, the rule speaks to corrective measures. So when you produced it, did you take corrective measures to make sure that the other party wasn't unnecessarily prejudiced by whatever caused the delay? Next slide. This is just the point that's often made that unlike fine wine, litigation rarely gets better with the passage of time. Another way of saying justice delayed, I suppose, is justice denied. Next slide. Judge Schulman.
All right, so here we are at the changes to Rule 1.440, which, as we have said, eliminates the at-issue requirement. I think many of us are going to really have to wrap our heads around this because, you know, defendant files a motion to dismiss and nothing can happen until that's resolved, or a motion to strike affirmative defenses. And if the case isn't at issue, it can't go to trial. And the reason why you have been receiving the DCM orders setting trial dates for the last year and a half, maybe even 2 years now, is because the committee has been talking about this for so long, about eliminating the at-issue requirement, that many in the 15th Circuit anticipated it, and our DCMs already do. So now it's set in stone. Next slide. The way it reads is now the failure of the pleadings to be closed will not preclude the court from setting a case for trial. So the message to you all, but also to us, is no stalling. And keep in mind that we understand the significance and the pressure that the amendments to these rules are creating for all of us. But it is the world that we're now living in, and this is part of the reason why we want folks to think about these changes as they first file or first appear in a case. It's so much easier to handle things at the beginning now under these new rules than at the end. Next slide. So here's the mechanics of this, and this also is where it gets very nuanced. You may need to read it a few times. I have to, and if you don't, then you're real quick. But subsection B, any case exempt from Rule 1.200. Let me pause here. Rule 1.200 is the rule that we spent a lot of time on at the beginning that really says we need to designate a case to a track. There are exemptions to that rule. For example, evictions, or any case that is required to be expedited or advanced, injunctions, things like that. Those are not subject to Rule 1.200. They're not subject to DCM. So this is talking about when you see exempt from Rule 1.200 or subject to it, that's what it's talking about. Your standard circuit civil jury trials, business cases will be subject to it. But if it is exempt, any party may serve a motion, no longer a notice to set for trial, a motion to set the action for trial. It must be served on the judge under subsection C1. Now this is applying to all cases. The court or the party upon motion may set a case for an earlier trial period than specified. We do this in county, and that is because many of our cases can be resolved long before the year that is allotted for, a streamlined case. If let's say it's a credit card case and perhaps one side doesn't have counsel, it might be a quick trial. We're setting those sooner. And we must do so with at least 30 days notice. The parties can also request it. There are times when a party says, I don't want to wait a year, I'm ready to go. File a motion, set it on UMC. And then under section C2, this does not apply to us in the 15th, but for those who practice elsewhere, any case with a projected trial period, that's what I was talking about earlier, the court must enter a second order fixing the trial period no later than 45 days before that trial period. So you might start to see some differences between circuits here. Next slide. And this is what I was mentioning, any case not subject to Rule 1.200, the court must enter an order fixing the trial period at least 30 days out. Next slide, Judge Curley.
Oh, yeah, continuances. They changed this rule in a very significant way, in my view. Motions to continue trials are disfavored and should rarely be granted. That's the language that they chose to use. There were a lot of alternatives. I know this rule was subject to a lot of debate with the Rules Committee, but this is where it came down. So, couple things I want to highlight for you. The changes themselves are fairly self-explanatory, and you'll see on the next slide. I'm not ready for it though. You'll see on the next slide, it tells you exactly what you need to put in your motions. The motions, as Judge Schulman mentioned before, this is the motion you're going to need to file if you want to change your track or you want to change your trial, the actual trial date, as opposed to just changing some of the other deadlines within the motion. It's going to be deemed a motion for a continuance. And what the motion provides in the third subparagraph here is that if a continuance is granted based on dilatory conduct of an attorney's named party, the court may impose sanctions. So they added this language so that if, as an example, we get all the time things happen that prevent a trial from going forward, and we're required to move the trial date. If these are the types of things that can be deemed dilatory conduct, the court, we're going to expect to see motions for sanctions. It's not the kind of thing that that we really want, but that is what the court is providing for. So suggestions: make sure your experts are ready to go. Make sure that trips and things like that you're planning your trips. Please don't plan them in an area where it's going to require a continuance for cases that are set. Things that do happen, as an example, today I had a hearing this morning about a plaintiff that didn't show up for the CME, and the party could not go to trial because they didn't have an opportunity to do the CME, and the plaintiff didn't show up, and now they're going to go back and do it again, but the case can't be tried. That's the kind of thing my guess would be. We'd be talking about sanctions and things like that. So there's some teeth in this now that didn't really exist before. Next slide. This is the format that's provided right in the rule, so there's really no excuse for not following it. So when you file your motions for continuance, please follow the format so that doesn't become a basis to deny or oppose the motion. Next slide. One of the mechanisms that judges now have and should likely employ are mitigating measures to address the delays. Other ways to have the trial go forward. Oftentimes folks will say, well, I need to have this person there live. Deposition isn't a substitute. Remote appearances by Zoom, things like that. Resolution of conflicts. I've never been shy about picking up the phone and calling a judge somewhere else to see if we can't work it out so that trials can go forward. Now the rule is putting an onus on judges to do what they can to resolve those types of issues so that trials can go forward. The point being, the direction from the Supreme Court is trials should go forward and continuances should be rarely granted. Next slide. This is the portion of the rule that deals with the order. That if a continuance is granted, it too is self-explanatory. What I would suggest when we get to this point, when you file your motion, attach to it a proposed order, and the proposed order should provide the court with a basis for granting the motion and should reflect very clearly what activity remains that would be permitted by the court. That'll make things a lot easier. And personally, if I can see it in an order and I can read it and it makes sense, it tends to move me in the direction you want. Next, Judge Schulman.
And I would note that in all of your cases that have been filed through today, you already have DCM orders because they, as we've said, are automatically entered. There is a bot that does it. The judges, just so you know, behind the scenes, we have all provided our calendar call dates through 2025 and 2026 to IT and case managers to input in the system. So the second a case is filed, there is some automatic process that happens that spits out the DCM order with the calendar call date. All the dates you see in your DCM order are flowing backwards from the calendar call date. For example, 10 days before file your pretrial stipulation. So, before fall hits and things get really busy, take a look at your trials for 2025 and even 2026. Those are getting, we're setting 18 months out for circuit jury. If you spot an issue, bring it to our attention now, because January 1st, our hands are going to be much more tied. And, we're all fairly liberal with granting extensions. We've all been in your shoes, but we certainly feel compelled to follow the rules as well. So take stock of what you have coming up over the next 18 months. All right, summary judgment. So we're not getting into the substantive summary judgment changes that have already happened. This is a new change that changes the timing. And I know we've already been through one change in the last few years of the 40 days and the 20 days prior to hearing. Well, now it's changed to eliminate the tie to the hearing date. So you have now, everybody should know by now that we're now following basically the Celotex standard. We've cited it here. Next slide. But the important point that takes place in January is that the rule has been amended to tie the deadline to respond to a motion for summary judgment to the date of service of the motion. And the rule says, in any event, the response is due no later than 60 days after service of the motion. So this is going to ensure adherence to the deadline set forth in the case management orders. Our DCM, there's going to be 1 or 2 changes, but we're now going to have to provide you some more clarity with when to file your summary judgment motions. Different judges have different opinions about the interpretation of this. I'm going to let Judge Curley give his. But let me address the next slide. So the Supreme Court deleted the requirement that the motion be served 40 days before hearing. Just take the hearing date out of your mind. And now the motion must be served consistent with the deadline specified in the case management order. And the reason you have to do that is because you still have to give enough time for the other side to respond and for that hearing to occur, all of which has to happen prior to counter call. So this is really pushing up the deadlines. And we're going to have to figure out as a bar and as a bench how we address this, because typically discovery cutoff is, let's say 30 or 45 days before counter call. Well, now your motion's got to be served pretty early. So keep it in mind, read the rule, read the case management order. You are in 2025 and beyond going to hear judges say, if you didn't get your motion filed on time and set for hearing, et cetera, you may be out of luck. Judge Curley, did you want to jump in?
Real quickly, to a couple things. As you can see from the slide that Judge Schulman has up now, the case management order can help here. If you all work out an agreed case management order on this, you can set your own deadlines for the summary judgment motion, the time to respond. In federal court, as an example, in the Southern District, it's 14 days to respond to a motion for summary judgment. And in federal court, using the similar rule, it's set by a local rule. So the local rule of the Southern District is 14 days. Others are 20, 28. Wouldn't surprise me if that's the direction we go in, to set some deadlines for a response. But in the meantime, as Judge Schulman said, this is what we're working with. I did reach out to a couple of committee members to get some idea of what they were thinking. Was the suggestion going to be that the courts ought to adopt their own rule, local rule? And still don't have an answer on that. So that remains to be seen. Case management order, try to agree on some deadlines if that's what you want. Otherwise, as Judge Schulman said, you're working with a pretty early deadline to get your summary judgment motion filed. Okay, next slide. Yes, in the comments and in the back and forth over and over again, this isn't new. I'm just reminding everyone that Rule 1.420B has a provision that says any party may move for dismissal of an action or of any claim against them for failure to comply with the rules of the court. Well, you got a bunch of new rules in place now that the committee notes suggested that this rule 1.420B is already in place and designed to deal with violation of those rules. So be careful. There's some teeth here now. I don't know. I can't tell you how that's going to play with things like Kozel. Remember Kozel? You got a 1, 2, 3, usually 3 times and you're out, something like that. Not so sure that's going to continue to be the rule, or Binger, things of that nature. It does put some things at issue that weren't really at issue before. We are, I think we're doing pretty good time-wise. I know we wanted to save a little time for questions. Could I get you to go to slide 63 real quick? Okay, 63, one back. So just so you all know, the Supreme Court, there's some corollary rules, so to speak, that they put on the judges to rule quickly and move things along. That's in play, and I would encourage, given the expediency of things now, I would encourage you, if a judge is sitting on something and you haven't gotten a ruling that you need, just file a notice or send them a note and let them know that there's an order outstanding and they need some help with that. I certainly don't take that the wrong way. I appreciate that. If it happens, I try to never have it happen, but every once in a while, with all things that are going on, it can. And then the next slide, Judge Schulman, you want to speak to this for a minute? The reporting of cases, Big Brother is watching, so to speak.
Big Brother is watching. We actually do have to fill out these reports. We have to submit them to our chief. Our chief is obligated to prepare reports for monitoring of all pending cases in circuit and district courts of appeal exceeding the time standards. And, you know, look, nobody wants to have to rat anybody out, least of all our chief, but this just shows you how serious the Supreme Court is about keeping us on track with the time deadlines and requiring you to stay on track. So help us help you is really the message. There's a lot of different reports that go out, including cases that are over 3 years old that got pushed back a few months, but we did include a snippet for your packet of those time standards we've mentioned. And there is a bit of a change, as we said, it's been from the date of filing. You'll have a little bit more wiggle room now if you don't get service right away. You can have up to 120 days from when that 18 months or 12 months starts kicking in. But again, this is to be cognizant of what we're having to report on.
All right, thank you. I'm going to take a breath now. Bridget?
Could you please tell the audience doesn't yet have the printout that the Palm Beach County Bar Association is going to be sending out to everyone. So for everyone who's attending, you will get from Ms. Clark or someone else from the Palm Beach County Bar Association a copy of this PowerPoint. And I also wanted to give a shout out. Judge Curley, is Matthew still with you?
He's hiding behind the screen over here, but he can hear you.
Okay. Well, we certainly want to thank you, Matthew, for all your hard work on this also. Judge Curley, do you want to introduce Matthew a little bit?
Come on over, Matthew. Matthew's interning with us for the summer. He's representing the Florida Gators. Good representative. Yeah, I know. He's not from Notre Dame, but that's okay. That's all right. That's fine, Matthew. I'm
Yeah.
still proud of you. So anyway,
Right.
he helped with the materials and really was invaluable. Judge Schulman, anyone you want to throw props to?
If I start saying one, I'll forget others, so I'll gather no.
And again, our thanks, of course, to the Palm Beach County Bar Association and to the Circuit Civil Committee and the Judicial Relations Committee who made this all happen. And I again want to thank my assistant, Dawn Whitfield. Does somebody, Judge Curley, do you want to tell the folks what they're going to be seeing in pages 65 through 71?
I absolutely would like to tell them. Okay. So the intention, couple things. The intention of the PowerPoint is so that when you get it, if you print it out, you have the highlights for the rules and you have the actual red line version of the rules. So you'll see the old rules and the new rules, and you've got the red line, so you'll see where it's going. Then after the page that Bridget, you mentioned, what you have is case law. These are federal cases that will help you with the proportionality analysis. They address things like some of the factors that the judges should take into consideration. They dispel the notion that one side or the other really bears the burden of proof. Although it's pretty obvious that the proponent, the person seeking the discovery should be able to argue persuasively that this is relevant information that's necessary for preparation or defense of the case. And then the person resisting discovery should be able to put together a pretty good argument if they're going to persuade the judge as to why it is unduly burdensome. And when I say unduly burdensome, I know that that phrase that in Florida case law, there's a lot of cases that talk about the burden, things like that, but it's a little different context. You've got relevance, as I said, and then you've got the burden. If the burden outweighs the relevance, then it's unduly burdensome. That would be the scale, so to speak.
Bridget, I see we have a bunch of questions coming in.
Yes, now we are starting to get those questions.
I can answer one of them. It has my name in it. About the wiggle room if service is not affected right away. So the amendment to, can you go to slide 64, please? Perfect. All right, so see in here, it says, for example, jury cases. And it says 18 months from date of service of initial process. Wait, go back to 64. You were on the right page. 60,
54.
64, you were there.
I'm
Correct.
sorry.
Good. 18 months from date of service of initial process on the last defendant or 120 days after commencement of the action, whichever occurs first. So if you haven't served all your defendants, and first of all, you're getting lack of service orders, but putting that aside, if it's been more than 4 months and you haven't served everybody, it doesn't matter. At 120 days, because that is occurring first, your time to disposition, your 18 months is kicking in, okay? So, but if you have everybody served within 30 days, your last defendant, your 18 months is kicking in. Please don't read this to delay serving defendants, because it's going to be hard when we do our reporting and when we pull these cases to be able to explain to the Supreme Court, oh, but they didn't get service yet. So for all intents and purposes, it looks on paper like you've blown the 18 months, but I want you to know that if you are having significant trouble serving a defendant, this rule does allow you that time.
Bridget, there are a couple that maybe I could address real quick.
Okay, perfect. Along those lines, I want everyone to know that when you get the materials, you will also get pages 49 through, I guess, 62, excerpts or the appendix of the rules. So you'll have not only the PowerPoint with all of the slides we've already gone over, and then these additional slides, the snippets, so to speak, but you'll also get the appendix with the actual rules.
So a few questions were asked about whether the rule changes the right to a hearing on a summary judgment. They didn't address that, so I don't think anything changes there. Corollary to that was a suggestion that it's not practical to deny late filed summary judgment or other such things. That the rule, we're going to follow the rule, but I would suggest to those of you, since the rule now has the same burden as a directed verdict motion, what I would say if you were in front of me is just file it as a directed verdict motion and I'll deal with it on directed verdict. So it's not necessarily a waste. Try to get it in on time so that it can be heard in a timely manner, but it's not a waste. Just turn it into a directed verdict motion, and that way you've had it briefed and ready for the court. If it's a motion that should be granted, yes, you're right. You'll spend more money getting there, but it's not going to change.
Judge Curley, it looks like Mr. Murad asked a question also relating to summary judgment, and I've heard this question not only relating to summary judgment, but also to some discovery disputes. Are hearings required, or can the court rule on the papers?
If the parties agree, the court can rule on the papers. There's having, anybody out there, any volunteers out there want to send me some cases or send us some cases that say we can just rule on the papers regardless, happy to take a look at it. But my research so far has been that our ability to do that is very limited in state court.
And part of the problem is that there's no deadline to, well, now for summary judgment, there's a deadline to respond, but That's presuming the move-in files it in enough time to allow the respondent to respond, but you know, say a motion to dismiss, I think we all agree, we can read these papers and rule on them. The oral argument isn't necessarily necessary. But the rules still don't provide for a response deadline in a non-summary judgment type of motion. So perhaps that's the future amendments, but until then, the best thing to do is if everybody agrees, if you're having trouble getting hearing time, like we said, set a CMC or say, we agree to let you rule on the papers and the response will be filed within X days.
Yeah, the rules do provide for pretty broad case management conferences to address, if it's properly noticed, pretty much everything.
And the rules take effect January 1st, 2025, as to most of the ones cited today.
And they apply. Pending cases and new cases alike.
Yeah, they're all
Oh.
January 1st, 2025 at 12:01 a.m. Are we going to be receiving additional resources such as more judicial clerks? The answer is an emphatic no.
I like the sound of that, though.
This was raised. I think it went up through the legislature. There was a Florida state senator that put forward a bill. It either didn't pass or it I don't remember the procedural history, but somebody out there did think of it and went for it. Unfortunately, there wasn't an appetite for it at this time. It's a budget issue. So at this time, it's yours truly and his truly, and your trial judge is doing all the work. So certainly the more you can do when you're preparing proposed orders, to really put substance in, the quicker you'll get your rulings.
Okay, we're up against the 1 o'clock ending to this, and there are many, many questions. We will try to save those questions and possibly get some more information out to all of you, or maybe reconvene as time goes on, another town hall. So we want to thank both of the judges, Judge Schulman and Judge Curley, very much. And again, thank the Bar Association. And before closing, Judge Schulman and Judge Curley, do you want to say parting remarks?
Judge Schulman, go ahead real quick, and then I'll.
I will say, you know, I always enjoy having conversations with the attorneys, how we can best handle these things. I'm always open to suggestions. We do listen to you. Please don't be afraid to provide suggestions and feedback, because I think we all want the same thing, which is to make everybody's lives a little more manageable despite the onerous nature of these rules.
Was well said. We'll take all the help we can get, and I would encourage you all to download the materials. We really think they'll be helpful, and when the time comes, take a real good study of them, and they'll highlight the good stuff for you, and the rest is hopefully all there to help you hit the ground running when we get to January.
Final comment is with gratitude again to the Palm Beach County Bar Association. They have recorded the CLE. So please, if anybody in your office, if any friends, family, relative, anybody that is a member of the Palm Beach County Bar Association, this CLE will also be available through the bar if you would like to share this terrific presentation by Judge Curley and Judge Schulman with anyone else in your office or firm or friends. Thank you.
Bridget,
Thank
before we log off, some people logged in with a phone number or first name or initials. They will need to email me at kclark@palmbeachbar.org. Otherwise, you won't receive the materials or the CLE course number. And please go ahead and do that right away. Thanks.
Thank you, Kathy.
Thank
Thank you, Bridget. Much appreciated.
Thank
Thank
you
you,
all. Take
guys.
care. Have a good afternoon.
Thank you all.
Thank you, everyone.
Bye-bye.